Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is particularly for the CPC students, Code of Civil Procedure 1908. Regarding Order number 5, Rule 2. Honor, the matter has come to the Supreme Court level. That's why I am making this video. It will become definitely useful for the CPC students. While deciding the case of National Insurance Company Private Limited versus National Building Construction India, National Building Construction India, NBCI Limited and others in SLP number 5383 by 2023 on 12/9/2023, Honorable two judges bench, Justice Anirudh Bose and Madam Bela M. Trivedi. They accepted that, please remember, if copy of the plaint is not annexed to the summons, it is not a valid service under Order 5, Rule number 2 of the CPC. This is crystal clear. Even in the class also I told you that the plaint should be made in duplicate and the copy should be supplied to the defendant along with the summons. What for also I have told you, it is to facilitate the other party or the defendant to make his defense at the time of trial or filing the written statement of his defense. Right, basically let us have a cursory reading of Order 5, Rule 2. Order 5 deals with issue and service of the summons. I told you that this relates to the defendant normally. Order 16 relates to the service of summons on the witnesses. Sections 27 to 32 deal with the service of summons on the witnesses as well as the defendant or any person also. This is the baseline. Now Order 5, Rule 2. Rule 2 says copy of the plaint annexed to the summons. This amendment has come in 2002. Right, the copy should be annexed. Right. Now, please remember, actually this is not for the supply. This case is not come to the Supreme Court for supply of the so-called copy of the plaint, but it came for the explanation or second as a limitation period. It came on appeal as a limitation period. Actually, the party, that is National Insurance Company Limited, they have filed the so-called written statement on the last day of the 90 days PR. But on that particular period, it was not accepted because of so many reasons. Now, the reasons are like this. So, please remember, Delhi High Court clearly disbelieved the incomplete service of the plaint. Why there is delay? Because these people stated that the plaint copy of last 2 pages, plaint was there, but the prior or other cause of action, last 2 pages was found missing. But before that, the High Court has delved deep into the matter. As what have all of you know the service of summons can be done in so many ways. Order 5 deals with the service of summons to the defendant. Here also, in 2 ways, the summons was served. Number 1, by the bailiff. So, through bailiff on 19/6/2017 is served. So, it shows the copy of the plaint is annexed, which was served on 19/6/2017. You may get a doubt who is the bailiff. Bailiff is normally we call him as process server here. There in cities and other places they call him as bailiff. Bailiff is a person actually who takes care of the court, who maintains order in the court, who will assist the judicial process before the magistrate. Here we call him as a process server. So here please remember this process was served to the process server. Normally they are court people, they will be very vigilant, they have enclosed a copy of the same. Second, by speed post. So by speed post also it was served on 22/8/2017. Here it is the copies last 2 pages were not made available. Of course, when these people have written a letter, they were made available on 27/10/2017. Now for calculating the period of limitation, the defendant wants to take the last date, that is 27/10/2017, as the 90 days period of limitation. Right? But the High Court, having seen the endorsements on the process service, they are satisfied that yes, in the first instance itself, the bailiff has given a copy of the plaint. So according to that, limitation period over. Okay. Even taking into consideration of the second day of service, that is on 22/8/2017, even then the limitation period of 90 days is also over. They cannot taste the ambiguity, they cannot taste the advantage of non-service or non-supply of 2 pages. What is this? They could have easily understand. So if the maximum, the plaint may be some 5 to 10 pages. If 2 pages are maintained, not available, do you think that the process of service is not correct? No, this is not correct. And therefore, Honorable Delhi High Court is 100% correct, as Order 5 to Order 5 Rule 2 is followed. So no use, appeal is dismissed. So please remember, the issue of very simple issue I told you in the beginning, Order 5 Rule 2 is very, very simple, but still it has come to the level of the Supreme Court. So such cases, you have to cite them whenever possible. So please read the case law and enrich your legal knowledge. Thank you very much.